Thank you. Welcome back to an inquiry into drug poisons and controlled substance amendment bill 2023. Welcome back to the members of the public watching via broadcast, and joining us this session from members from the Federal Community Legal Centre and also the Australian Lawyer Alliance on Zoom with the Federation of Community and Legal Services. So we've got Ms. Lee Carney and Mr. Sam Coleman. Also with us, joining us, Australian Lawyer Alliance, Mr. Greg Barnes on Zoom. Welcome. Just before I proceed, I'll quickly read this information to you both. Regarding evidence you've given today, all evidence taken is protected by parliamentary privilege as provided by the Constitution Act 1975 and further subject to provision of the Legislative Council standing orders. Therefore, the information provided during this hearing is protected by law. You are protected against any action for what you say during this hearing, but you go elsewhere and repeat the same thing. Those comments may not be protected by this privilege. Any deliberately false evidence or misleading of the committee may be considered contempt of Parliament. All evidence is being recorded. You'll provide a approved version of the transcript following the hearing. The transcript will ultimately be made public and posted on the committee website. Just for recording purposes, could you please state your full name and the organisation you're representing, please? Could I start with Lee?
Lee Carney. I use they, them pronouns, and I'm the Director of Policy and Advocacy at the Federation of Community Legal Centres.
My name's Sam Coleman. I use he, him pronouns. I'm a lawyer at an individual community legal centre called Youth Law.
Thank you, Sam. And Greg?
Sure, it's Greg Barnes, SC. I'm from the Australian Lawyers Alliance.
Thank you. Welcome. I understand you both have made a submission. We'll invite you to have an opening statement before I open the committee for questions. So if you'd like to start, Lee.
Thank you. I know that we've already acknowledged that we're meeting today on Aboriginal land, but I'd like to pay my respects to elders past and present and recognise the significant and disproportionate impact of laws which have criminalised cannabis use on generations of Aboriginal people in this state. The Federation of Community Legal Centres is the peak body for Victoria's 50 community legal centres who've been at the forefront of helping community members experiencing financial hardship, injustice and mistreatment with free, high-quality legal help for over 50 years. Community legal centres see firsthand the long-standing and significant human impacts of current laws which criminalise people for minor possession and use of cannabis. I will briefly outline 5 reasons why we support the bill and 3 amendments to strengthen the bill. Firstly, minor cannabis offences are disproportionately enforced against people experiencing poverty, structural oppression and over-policing. As the Victorian Aboriginal Legal Service will highlight later today, Aboriginal people in Victoria are significantly overrepresented in police and sentencing statistics for minor cannabis offences. Aboriginal people are more likely to be arrested, less likely to receive a caution from police, and more likely to be required to attend court and to receive a punitive sentence. Children and young people, particularly children in out-of-home care, are also disproportionately arrested and criminalised for minor cannabis offences. The Fitzroy Legal Service will give evidence later today about the disproportionate impacts on people evicted into homelessness and people experiencing family violence. Secondly, criminalisation for minor cannabis use causes real and profound harm to thousands of Victorians every year and is not an effective deterrent. Being arrested, interrogated and charged by police, dragged through the courts and dealing with the long-term consequences of a criminal record for drug-related offences has serious negative consequences on individuals, their families and communities. Negative experiences with police and courts often results in people being reluctant to later seek help if they are a victim of crime or experience family violence, and is a major obstacle to people accessing healthcare or treatment if they are experiencing drug abuse or addiction issues. Thirdly, criminal records for drug-related offences create long-standing stigma, discrimination and consequences out of proportion to people's behaviour. Having a criminal record that says possession or use of a drug of dependence reduces people's employment opportunities, access to housing and social services, makes it almost impossible to volunteer in your local community, particularly with children, and denies Victorians opportunities to travel to many countries overseas, such as the US. While the Victorian Equal Opportunity Act has been amended recently to provide protection against discrimination for people with spent convictions, it doesn't protect people with irrelevant criminal records from discrimination. Fourth, the bill is a clear step towards a harm reduction approach that will create better public health outcomes. I think you've already heard that in detail today, but we agree with the public health experts that it will reduce health risks associated with unregulated cannabis use and reduce negative health impacts of contamination or harmful substances being included in cannabis obtained on the black market. And finally, the framework proposed in the bill is safe and low risk. We've seen from the implementation of the ACT model and how reforms in many parts of North America, Europe and parts of South America, which replaced prohibitionist policies with decriminalisation and increasingly legalisation, supported by health-based responses, are effective at improving health outcomes and community safety while reducing the very real harms caused by criminalisation, the long-term impacts of criminal record stigma and discrimination and organised criminal activity related to black market sales. In terms of amendment, the bill could be strengthened by, firstly, decriminalising personal possession, use and cultivation for adults and children, and I'll hand over to Sam shortly to speak to that. Secondly, automatically expunging minor cannabis charges from people's criminal records. I think that other people have already given evidence to this, but we would support adding a provision that directs relevant Victorian government agencies to permanently remove minor cannabis charges from people's criminal records post-decriminalisation to ensure discrimination doesn't persist after the reforms come into effect. And finally, clarifying and authorising conduct consistent with the purposes of the bill. Again, this has been covered this morning, but we would also support amendments making clear that authorisation should apply for marijuana seeds in the same way as plants, that sharing a joint or edible with another adult shouldn't carry criminal consequences, that principal place of residence requirements shouldn't disadvantage people experiencing homelessness, and common sense guidelines for growing marijuana plants in backyards in very rainy Victoria, such as greenhouses. I've listened to the committee's questions this morning and could provide additional information on the negative impacts of transferring current criminal offences to the infringement system, and learnings from the practical administration of other application-based expungement schemes in Victoria. I'll now hand over to Sam.
Thanks, Lee. I'd just also like to acknowledge the traditional owners of the land, pay my respects to elders past and present, and affirm that sovereignty was never ceded. I'm a lawyer at a specialist community legal centre called Youth Law. We assist vulnerable young people in Victoria under 25, so young adults and children. And I welcome the opportunity to address the committee and strongly support the Federation's recommendation that this bill be amended to extend decriminalisation to children as well as adults. The bill rightly recognises that personal cannabis use and possession is a health issue, and that its criminalisation does more harm than good. It acknowledges that cannabis-related offences are disproportionately enforced against Aboriginal and Torres Strait Islander people, young people, and those generally experiencing disadvantage. However, by maintaining criminalisation for those under 18, the bill does not address the entrenchment of disadvantage experienced in childhood. Kids use cannabis for the same reasons that young adults do, often in response to trauma, family violence, homelessness, or mental health challenges. And criminalisation does not deter young people, young adults and children from cannabis any more than it resolves their trauma or disadvantage. Instead, it pushes them further into the justice system, creating lasting consequences that extend well beyond adolescence. Research consistently shows that early interaction with the criminal justice system increases the likelihood of reoffending. It disrupts access to education, employment, housing, and compounds disadvantage rather than addressing the underlying issues that lead young people to use cannabis in the first place. A childhood drug possession charge, or use charge, or cultivation charge can have severe and long-term effects that are entirely disproportionate to the offence. Even a spent conviction can still be disclosed in several contexts, such as a police check for certain kinds of jobs, working with children's checks, which is very common, or travel applications. Having a prior offence as a child, even a police caution, can disqualify an adult from diversion programs. For kids, being labelled a criminal both by the system and by themselves entrenches disadvantage and stigma, making it harder for young people to access support and turn their lives around. As the second reading speech highlighted and has been already addressed this morning, over 1,100 Victorians were jailed for cannabis possession in the last 3 years. Whilst this bill addresses this issue for adults, it leaves children behind. The disproportionate policing of Aboriginal and Torres Strait Islander children and children in out-of-home care means that they will continue to bear the brunt of a system that this bill is designed to fix. Victoria has an opportunity to do even better than the ACT here by extending decriminalisation to children, and I urge the committee to do so by strengthening the bill. Thanks.
Thank you. Greg, would you like to make an opening statement?
Yeah, sure. Thanks, Chair. We firstly acknowledge that we meet on Aboriginal land and pay our respects to elders past, present and emerging. Can I just indicate the Alliance endorses the views that have just been put, so I might try and take it in a different direction for you. The purpose of the criminal law, as we all know, is to deter people from committing or undertaking antisocial conduct or conduct which society deems to be criminal. And the purpose is both general deterrence and specific deterrence. And if the law does not deter people, then it has no utility. In relation to drugs, generally, and I'll come to cannabis, as we all know, there is zero evidence that drug laws have any deterrent effect. As the Economist newspaper has said on a number of occasions, there are no wins in the war on drugs, only Pyrrhic victories. In relation to cannabis, and the reason we support this bill, alongside the reasons outlined by my friends, is that this is evidence-based policy. We know, and no one could argue to the contrary sensibly, we know that there is no deterrent effect. We know that, and I can indicate this, lawyers use cannabis. People from all walks of life, doctors, police officers, all use cannabis or have used cannabis at some point in their lives. Knowing, of course, that it is formally illegal. And so you've got to ask yourself this question: why would you continue a policy which is such an abject failure in terms of deterrence? Now, it's said, oh, well, you're giving a green light to drug use. I mean, there is, again, no evidence that people suddenly start using cannabis because, oh, good, it's no longer illegal, I can do it. They do it anyway, those who want to do it. It's important to note also, and as has already been said, the disproportionate impact of cannabis. Magistrates have to sit there every day and deal with cannabis cases. And I think if you surveyed magistrates, they'd say it's a waste of time. I talk to police officers about it and they say it's a waste of time. Lawyers talk about it and say it's a waste of time. I remember talking to someone from a drug court here in Tasmania, where I am, who once said to me, this was a judicial officer, who once said to me, workers come along to the drug court and they say, oh, well, he hasn't given up drugs, but he's no longer using ice, he's using cannabis. And you have to sit there and give these people a lecture. And he said, it's often occurred to me that I'd rather them be using cannabis than speed. People don't commit offences, generally speaking, while they're using cannabis. So to wrap it up, and this is not a left-right issue, and I think it's important to note that for example, the law and economics movement at the University of Chicago, which is very much oriented towards free markets, would argue that good public policy focuses on harm reduction because that's more cost effective for governments. And that secondly, those who are on the left in relation to law reform debates would say that there is a disproportionately adverse impact on certain elements in the community and a disproportionately adverse impact in having a cannabis conviction, particularly for young people. So it's not a left-right issue. It's smart policy and smart justice that we're talking about here. And you shouldn't let the Herald Sun or any other news outlets deter you from good policy, because the winners are those you represent. Thank you.
Thanks, Greg. Thanks, Lee and Sam. I'll take your opening statement. I'll quickly ask a few questions, then I'll open up to the committee. We listen to your comment. Let's law make no deterrence. I think that's have different point of view from various parties, but I'll focus on listen to your recommendation in relation to number 2 recommendation that our inquiry has got submissions, got evidence that kids shouldn't access, underage shouldn't access any cannabis, has a harm effect down the track for their growth up to the age of 25. Now, I understand your work, have a legal point of view that when it's legalised and that there are offences and they'll be subject to the number of people being charged or incarcerated. But I'm just wanting to know from your point of view, from a health aspect, so from no legal aspect, in relation to those who are under 18, why your recommendation to open up and amend the legalisation of personal possession, use and cultivate of small quantity for children as well as adult, I understand the adult part, but with the children under 18, how's that benefits in relation to those underage, related to the health-wise, not from the legal why we're getting charged, I understand that situation, but related to the health-wise, could you expand on that relation to how you balance related to a person being charged and relation to their health aspect of growing up through age, and relation to having opened up this, would that have more accessibility for those underage to access cannabis?
So I'm happy to go first. The first point I'd make is that we don't dispute the public health evidence about the health impacts on children. We trust the evidence and doctors around some of the challenges around people who are underage using cannabis, particularly in relation to particular mental health issues and their brain development. However, what we recommend is a decriminalisation approach for children. So we're not recommending an authorisation approach, as is the case with adults, but rather that children shouldn't be criminalised when they do possess, use or cultivate cannabis. And the reason for that is because we think that the most effective way to support children, particularly children from disadvantaged and marginalised backgrounds who are experiencing problematic drug use, the best way for them to get the help that they need to address the underlying issues that are often leading to them deciding to use cannabis, such as childhood trauma, mental health issues, is to facilitate them to get the best help and support that they can. When cannabis, possessing, using or cultivating cannabis is a criminal offence, what that means is that children are not going to go to a family friend or a parent or a teacher or a sports coach and say, actually, I've been having a bit of a problem with this, I've been using this, I've been feeling a bit sick. What it means in practice is that they will be less likely to seek help, to seek treatment, to talk to others that they can safely use cannabis, they can moderate their cannabis use so that they can learn and educate themselves around what the impact of using cannabis is on their lives and their development. as I said before, we also see how children from marginalised communities are disproportionately affected, and they'll continue to be further marginalised and deterred from seeking support. We think it's, and I think Sam might elaborate on this more, but we know that harmful use of alcohol and drugs by children and young people is often a form of self-medication. But what we do support is similar to age-based prohibitions around vaping or cigarettes or tattoos or body piercing. Government regulation should focus on adults' behaviour towards children rather than imposing criminal offences on children for behaviour that is lawful for adults. I can expand on this more, but as an example, buying cigarettes, it's not unlawful or a criminal offence for a child under 18 to buy cigarettes, but it is unlawful for an adult to sell cigarettes to a child. And there are current provisions in the Act that is being amended by the bill that will continue to make it a criminal offence for an adult to sell cannabis to a child under 18. I would also say that there was a 2021 youth forum where young people had the opportunity to share their views on this issue, and where they shared that how criminalising cannabis creates perceptions that young people are unfairly targeted by police because of their age. It's more likely to foster distrust of police and the justice system. It doesn't actually affect rates of cannabis use among young people, and it forces young people to access the unregulated illicit market where products are much more likely to be unsafe.
Any comment, Greg?
Well, no, I would agree with that. And again, it's not about a free-for-all. It's not about sending a signal that, the current structures don't work, and they do mean that cannabis use is much more hidden by young people than it would otherwise be because of fear of police or being reported to police, particularly by teachers and others. So, again, I can't understand any argument about this. Why wouldn't you focus on harm reduction and keep young people out of the justice system as much as you can?
Thank you.
Thanks, Chair. Lee, I might just continue on this theme just to clarify. So you're in favour of provisions that would retain penalties for the supply of cannabis to those under the age of 18, including gifting?
Yes.
Yep, okay. Just want to be clear on that.
I just wanted to make sure.
Yeah,
Yes,
no,
that's right.
That's fine. The other is, and we had an interesting, we were in the ACT Tuesday, was it? Tuesday. Had a really long session with ACT policing. And one of the things they talked about was the way that what evolved from the simple cannabis offence notices into the drug offence notices operates with respect to everyone, but I can see also with respect to children, that effectively there's still the simple cannabis offence notice effectively still operate for children where there's a kind of nominal fine, but also where there's essentially a confiscation of product. Would you support the ability for product to be removed, confiscated from those under the age of 18 who had it in possession but not have a criminal penalty attached to that?
Yes, we would continue to support the confiscation of cannabis from children.
More broadly, we have had evidence about, particularly from Burnett and the Alcohol and Drug Foundation earlier, about this kind of being a step, but probably not the step that they'd want to fully take. I wonder if you had a view on whether the steps that we should take in Victoria with respect to cannabis regulation should be just this one, which is essentially the decriminalisation of personal possession and cultivation, or whether you would support moving a step further and going to some sort of regulated market approach. I'm happy for either of you to, or both.
So in relation to this bill, we agree that it's kind of one step forward. We support authorisation as a step in the right direction. However, our position is that decriminalisation would be a much better approach.
So what do you mean by decriminalisation?
So in the current bill, the way that it operates is that it is illegal to possess or use cannabis unless you have authorisation, and so the bill authorises adults to possess or use cannabis. A decriminalisation approach would be to remove, effectively create an exception or a carve-out from the possession and use criminal offences, for example, for a small amount of cannabis for personal use.
Do you, and Greg, you may want to answer this as well, do you
Yeah.
do you think we should go further and have a regulated market?
Well, I do. And the reason I say that is because if you regulate it, you do two things. Firstly, you take it out of the black market, or people are less likely to access products in the black market because there's no product control. That's the first one. We know that from prohibition. Prohibition does not work because all it does, as you're seeing in Victoria with tobacco, all that it does is increase the opportunity for what we call super profits. And people will, in terms of the rational actor, will take the risk of selling cannabis on the black market because the chances of being caught are, in their mind, less than the chances of making a super profit. So, I think what we would say is that at the end of the day, there ought to be a market-based approach taken, as there is increasingly around the world. But the first step, decriminalisation, will at least, I think, get the community more relaxed about the issue of cannabis. I mean, the thing about cannabis, it is less harmful than alcohol and tobacco. And that's what the science tells us. So why are they legal and cannabis not legal? You've got to ask yourself that question. This is an area where there is a complete lack of rational policy. And there's prejudice, but no rational policy. And the only winners are drug sellers.
That's all for now.
Thank you, Ryan.
Thank you, and thank you for your submission to this inquiry. I really appreciate you presenting before us today as well. I want to talk more about, you both talk in your respective submissions around a health-led approach, noting that decriminalising cannabis will allow public resources to focus on health, rehabilitation and underlying causes for substance use. Can you speak more about the effectiveness of these alternate approaches and the burden that it could lift off the legal system more broadly?
Perhaps I'll quickly go first.
Yes, please.
I don't know if you've been down on Magistrates Court or a local court, as it's called in some jurisdictions. The number of possession of cannabis cases that are in the system every day is extraordinary. And it's a waste of court's time. Complete waste of court's time, because, as I said, there is no evidence, as in no evidence, of any deterrent effect. So why would you waste the court's time?
Maybe as an example, I can talk to the Planet Youth school-based drug prevention approach, which in Iceland shifted substance use among children from one of the highest rates to the lowest in Europe. This has been piloted in South Australia and New South Wales, and the Planet Youth approach builds on evidence that children are less likely to use substances when they have strong relationships with their parents, positive school environment and supportive community environment, and when you roll out protective factors such as parent education, peer groups and whole of community prevention approaches. So embedding the health-based response in places where children meet and congregate, like schools, like local social groups, sports clubs. I would also note that the previous Victorian Parliamentary inquiry into cannabis use did recommend that the Department of Education and Training facilitate a trial of the Planet Youth program in Victoria.
Yes.
And we, strongly support resourcing the health sector to be able to support the implementation of this bill by implementing similar programs across the state.
I might give a little case study if that's okay.
That'd be great. Yes, please. Thanks, Sam.
This is about a young woman called Kayla. Kayla is a young woman with very complex mental health needs, mental health issues. She was homeless, long-time victim of family violence and sexual violence. She was engaged with housing services and engaging well at this time, but unfortunately was one of those young people where there's just no solution at the time. So she was sleeping rough, and she was caught smoking marijuana, or cannabis. We know that cannabis is disproportionately smoked by people sleeping rough. She was searched under the Drugs, Poisons and Controlled Substances Act, which is a specific trigger for her, and it caused a mental health event, and she was charged with 4 counts of indictable assault police in the course of a breakdown, and was sent to Dame Phyllis Frost for a number of months to the Marmac unit, into the mental health unit. She was sleeping rough, but she'd escaped a family violence situation and was doing relatively well in terms of her engagement with supports. She had a really, really fantastic AOD worker, and because of, I think, general underfunding, that AOD worker was functioning well outside of her PD, essentially as an outreach worker when she wasn't supposed to be. Her being sent back to custody was a tremendous setback. She ceased her involvement with her local area mental health service. She stopped taking her depot injections. And when she was finally released, we essentially lost her again. And she fell back into negative peer networks and incredibly unsafe situations. That sort of, I just wanted to address both the health aspect and the burden on the state as well. That many court hearings were precipitated by this event, a long stint in custody, the work of lawyers and other services.
Thank you. Thanks, Sam. I might just quickly throw to what happens with young people or children if they are picked up for cannabis. Is diversion programs, and just more broadly, are they effective? And what improvements would you make in reflecting on this bill that is before you today?
Sure. Can you say that again? Sorry, Rachel.
Just reflecting on diversion programs, or what's
Yep.
currently happening for children that are picked up with cannabis possession currently, or what is maybe a consequence of this bill that's before you today. How would you reflect on the efficacy of diversion programs, or what's currently happening with young people today?
Diversion's obviously a far more preferable outcome than a formal finding of guilt from the court. But in my view, any contact with the system whatsoever is criminalising. Stigma isn't just associated with a sentence by a court, but it's any contact with the court. It's coming to court, it's speaking to the police. And especially for children, at some point, there's a point which every practitioner, I think, that works with kids knows that at some point, if they're being told they're a criminal over and over again, they'll start to accept it. This is, I think, called labelling or in the literature, but the legislature has known this for a long time. It's provided for in the Children, Youth and Families Act that there's a general injunction to avoid stigma, and it's also a part of sentencing as well. I think the proposed amendment to the bill would, even though we're certainly in favour of diversion programs and they work well, we're insisting that cannabis personal use is a health issue, and that any contact with the system is a risk for criminalisation for young people.
As you're aware, there are Youth Justice Act amendments that have recently come in around the sentencing kind of hierarchy and diversion and cautions. It's probably a bit early to tell exactly how they will operate in practice, but under the current system anyway, and even in the Youth Justice Act, there are barriers to children being able to access diversion. For example, like the police informant has to consent. I've previously practiced as a youth crime lawyer, and what we see is that kids who get picked up for minor possession charges who also, might have had negative interactions with adults, authority figures, often because of experiences of childhood trauma and family violence, are more likely to be the ones who might, kind of swear, call the police officer names, and in that situation it's really, really difficult for them to get diversion even for minor offences. And so you can see this kind of disproportionate impact of how children from, low-income backgrounds with mental health issues are more likely to be criminalised.
Thank you. Thanks for your response.
Michael?
Thank you, Chair. Thank you all for joining us. Lee, I'm going to jump on something that you said in your opening remarks. You flagged that you had some comments you could give about the infringement system, which is applied in the ACT and some other jurisdictions. I'll be very keen to hear what you have to say about them.
So community legal centres provide legal help and advice and representation in relation to thousands of infringements each year. We wouldn't support moving these criminal offences to the infringement system because of how the infringement system currently operates. Maybe I'll just make kind of 3 points. The first point is that under the current Victorian legislative scheme, you can still go to prison because you're too poor to pay your fines. So if you have fines and you cannot pay them, the sheriff cannot take kind of enforcement action against you because you don't have property, you don't have an income. What happens at the end is that you go to the magistrate's court and you're placed under kind of what's kind of called an imprisonment in lieu order if you continue to not pay it. And by this stage, every stage at which you don't pay a fine, it increases. It could be thousands more than the initial fine that you are often unable to pay. And then with an imprisonment in lieu order effectively becomes a warrant to imprison. And so under our current infringement system, there is still a risk of imprisonment, but it's obviously disproportionately, it's unjust in how it applies, because if you were fined for, minor possession of cannabis and you had a stable income and, a lovely house in Toorak, then it's unlikely that you would end up being imprisoned. But if you are unable to pay your fines and they kept getting bigger, then you have a higher risk of being imprisoned. Secondly, we see how engagement with the infringement system, as I've explained, can also lead to people ending up in the court system, and the same barriers to kind of seeking treatment. Even if you apply through the court for kind of special consideration of your fines for them to be withdrawn at later stages when they've gone to the enforcement stage, they do still appear on your criminal record even though they are infringements.
And that's regardless, or if you've gone through the court system?
That's so. If you have what are called special circumstances, so if at the time that you were fined, you were experiencing homelessness, mental health issues, you have an intellectual disability, or exceptional circumstances such as family violence or financial hardship, you can apply to the court for your infringements, for your fines to be dealt with through the court. But if an order is made by a court, it ends up on your criminal record, on your court record.
Thank you, yeah.
Does that make sense?
It does, yeah. Yeah. So, again, affecting the people who would be most vulnerable.
That's right.
Be more likely to have a criminal record as a result. Yeah, thank you. No, that's very, very helpful information. You also touched on Planet Youth, the Icelandic model, and I'm curious if there's anything that you can maybe provide to us or notice with some pointers and some resources, or if you have them yourself, if you can provide them to us, it'll be terrific for us to have a look at, because I think we can all agree, whatever the model, the less young people using cannabis, the better. I'd also like to, if I briefly have time, and put to all of you, whoever feels best qualified to answer. In the FCLC submission, you say that more than 12,000 Victorians were charged with cannabis abuse in the 3 years to June 2023. How many of these, if you know, were in full isolation and not connected with other offences?
I would have to take that question on notice. I don't know off the top of my head.
Sure.
Anecdotally, anecdotally, but I'll pass to Sam as well.
Yeah.
Our experience is that often these offences do come with other offences. But yeah, I've definitely seen quite a few where this is the only offence as well, where it's just a possession and use for minor personal cannabis. But I don't know off the top of my head. Sam?
Yeah, I also don't know, I'm sorry. But I've certainly seen lots of both in isolation and with a host of other charges, yeah.
Yep. Yeah, thank you. Mr. Barnes, would you have anything to add to that?
No, I don't, but my experience over many years is often coupled with other offences. But of course, that doesn't mean in any way or detract from the argument decriminalisation.
Yeah, thank you. Thank you all. Thanks, Chair.
Thanks, Michael. David?
Yeah, thank you, Chair. And look, thank you very much for your very insightful contributions today. It's really appreciated. Could I ask you about in terms of looking at the sort of utility of the bill that's being considered, have you applied your minds at all to the question of how it might interact with other legislation? So, for example, when we went to Canberra, there was discussion there about the fact that you can decriminalise cannabis, but, for example, people on parole are regularly subject to urine checks, and if you test positive, you're pinged. I'm wondering, is that a question that you've considered in terms of possible adequacy of the bill?
Well, sorry, I might just go first. I think the first thing, of course, is that you amend the Drugs, Poisons and Controlled Substances Act. In relation to parole and parolees, I chair the Prisoners' Legal Service in Tasmania, and it's exactly the same as Victoria. And we've had this battle. We say that because the urine testing is there to pick up illicit substances, and we've had a discussion around the fact that many ex-prisoners use cannabis. They use cannabis as stress release because most of them get very little through care from the prison system when they come out, and also they're often dealing with trauma. And so they use cannabis, and it's a very unfair use by the parole board of its powers. But if you, and I'm not sure it would change if you decriminalise cannabis use as opposed to legalising. I think it still provides an opportunity for the parole board to adopt some form of policy that says that it regards cannabis as being problematic. And that I think is a problem unless you legalise.
We haven't given it detailed thought, but we can take it as a question on notice. We would support kind of consequential amendments to other pieces of legislation consistent with the purposes of this bill. Sam has a specific point as well.
Oh, I think one thing I'd like to take on notice is the way it would interact with search powers, specifically the Drugs Act search power that I mentioned before in that case study. But yes, we'd have to get back to you.
There'd been a number of bills that would interact with it as well that are related to, there's been amendments put forward around expungement as well. And so there's other pieces of legislation, but also various pieces of regulation and government guidelines that would need to be released, for example, like Victoria Police and Australian Federal Police information policy around what types of offences would be disclosed on a criminal record check, working with children checks. There's quite a wide-ranging number of pieces of legislation that would need consequential amendment to give effect to the authorisation approach in the bill.
Thank you. I'm happy to take that on notice. That would be appreciated. In working with some of the community legal services out in the West, been a lot of discussion about bail going bad, ending in remand. I'm just wondering if you could sort of perhaps inform the committee a little bit about the reality on the ground of those problems, particularly for young offenders, and the degree to which the criminalisation of cannabis is a factor in that cesspit.
So you're right. So while minor possession and use charges remain crimes on the statute books, what it does mean is that a child who is on bail, who is picked up by the police for possession of a small amount of cannabis, will be returned before a judicial registrar or a judge in the children's court, and is at risk of having their bail revoked and being sent to a youth prison. There would still obviously have to be consideration of the factors under the Bail Act around unacceptable risk, etc. But committing a criminal offence on bail is something that has been a matter of debate, has been kind of a criminal offence for adults at some time. There's kind of a discussion about review of bail laws, I suppose thinking about what the situation might be in the future, depending on bail laws now versus how what bail might look like in the future if they're reformed as well. We have serious concerns around any risks around children and young people, but also adults having their bail revoked because of breaching an offence of bail, that being kind of reintroduced in the adult system as a charge in and of itself.
Mr. Barnes may want to make a comment, Chair.
Well,
No, look, I would agree with that, and to trigger detention, loss of liberty, simply because you possess cannabis just seems extraordinary in the 21st century. Just extraordinary.
Thank you.
might have time to one more.
Sure. Thank you, Chair. Good afternoon. Thank you all for your contributions through this inquiry process. I might start with you, Sam. Are there any other specific examples or case studies that you could give us that share, highlighting how current laws that criminalise minor possession and use is impacting people's lives, particularly children and young people?
Yeah, thanks. I'll give another case study if that's...
Yeah, go for it.
This, to my mind, is an interesting one because it has very few sort of variables. This is a guy, I'll say Jake, like a lot of young people, young adults that we work with. Jake was doing VCE when school went remote, and in year 11 he just couldn't. We see this a lot. It was too much, the remote learning, and he dropped out of school. That had really significant effects on his mental health, and he started self-medicating with cannabis. He was picked up by the police and given a caution as a 17-year-old, and that spurred him to self-refer to YSAS, a youth AOD service, and he was engaging really, really well. He did several stints at detox and rehab, which is where I met him. And then once he was 18, he was picked up again for just for possession of cannabis. So I guess this is an example of where it's just cannabis in isolation. Because of the very broad discretionary powers that police at station level and prosecutors at court have with respect to diversion, whether or not they give consent to diversion, they ultimately didn't consent to diversion. An 18-year-old without any priors who'd been charged with possession of cannabis. And the reason was because he had been given a caution when he was 17, and that the support letter, the AOD support letter that we provided, stated that whilst he was working really, really well on his cannabis use, he hadn't yet ceased use. And we don't have a way of reviewing that decision by police that I'm aware of. And he had to plead guilty to that charge, and then his what was started off as a self-referral to a health service became something ordered by the court as a special condition. Yeah, this had really terrible criminalising effects on this young guy. Yeah.
Thank you. And I might stay on the topic of policing and bring you in, Lee. Where do cannabis-related offences sit in terms of how particular communities are over-policed or what we're seeing in the data?
As I mentioned earlier, we do see how there are particular communities who are more likely to be criminalised for minor cannabis offences. Aboriginal people, people kind of experiencing poverty, children and young people, particularly children in out-of-home care, children with disability, children from racial minorities are much more likely to be targeted. We also know that there are particular consequences around people experiencing homelessness who are more likely to be over-policed, more likely to be charged under the possession and use of cannabis, where it's really a small personal amount. There's also Fitzroy Legal Service will speak to this more this afternoon. They have a number of case studies they can share, but there's a concerning trend that a number of community legal centres have reported around people who are experiencing family violence in the middle of a family violence incident, calling police for assistance, the police attending, and then seeing that there's a small amount of marijuana at home, and then saying that they have no choice but to charge the person experiencing family violence who called police for help with possession of cannabis charges. So we can see how people who are more likely to be experiencing hardship, injustice, poverty, homelessness, family violence are unfortunately more likely to be affected. In the youth space as well, it's stark, the data around the children in out-of-home care who've been removed from their families and homes because of child abuse, neglect, are much more likely to have these kind of minor cannabis charges, whereas in comparison, talking to teachers in schools and private schools often talk about how in those contexts, if a kid is found, it's kind of dealt with within a school. There's discipline provided by the parents at the home, but rarely do we see anyway children from kind of affluent backgrounds being charged for these types of criminal offences.
Thank you.
Thank you. Thank you. Just mindful of time, I'll quickly ask one question on notice before we finish off. In your experience, who is introducing young people to cannabis? And also, should there be penalty for supplying to minors with cannabis rather than charging the young people in possession? So I know the time is running, we're only going through time, but we did on notice. It'd be much appreciated. From a legal perspective, those two questions.
Chair.
Okay.
Sorry, Chair, could I just ask for another one on notice as well? Is that okay? Just, Greg, just to bring you in, you spoke about the burden that cannabis-related cases is placing on our courts and our justice system. If possible, on notice, if at all possible, could you provide some sense of the proportion of what that caseload represents? Right. Even a ballpark percentage would be useful.
We'll try. I mean, one of the problems is trying to break it up, to individual offences versus, for example, drug driving plus possession. I think the data is difficult to get hold of, but so a lot of it's anecdotal. But I think if you talk to magistrates,
Craig, if you could come back with us with that answer, would be much appreciated.
Yeah, well, I'm just contemplating how I can. I'm just contemplating if I can take it on notice and come back with something useful. That's all.
Okay, thank you.
Thank you.
Fair enough.
Just on behalf, first of all, thank you so much for your submission. And thank you much for your time, for your contribution today. Much valuable lesson to a legal perspective as well. So thank you. Could I ask Hansard to stop recording, please?